You have alluded to the fairness doctrine, which I know is something that you are personally very, very interested in and have been concerned about for many years. And I suppose, correct me if I'm wrong, that the telling argument about the fairness doctrine is that it could have a chilling effect. Chilling effect in what way?
It makes you think about what you're editorializing about. It makes you say, you know, if I say this, do I have to put the other side on? I'll give you a funny example. At one point, I was working for Lee Iacocca at Chrysler, and we wanted to use our ad. Seatbelts weren't mandatory in those days. And we wanted to put into an ad that seatbelts should be mandatory, like a public service announcement. We'd pay for it, it'd be our ad space. Nobody would take it. And we said, well, why won't you take it? Well, then we'd have to put Ralph Nader on, who believes we should have airbags. And then we'd have to put the libertarians on, who say you can't tell me what I do in my own car. And that's 2 for 1. They'd be free, and we'd lose revenue. And so we never were able to put that ad on television. That's how the chilling effect worked.
What about the condition currently of the fairness doctrine? Where does it stand? Is it still in effect? If not, what happened? And you had a personal involvement, in fact, in this.
Well, I did. I headed a coalition that included the New York Times, the Washington Post, the Los Angeles Times, ABC, CBS, NBC, Fox. We went to court and asked that the fairness doctrine be declared unconstitutional. The Federal Communications Commission agreed with us and said it was constitutionally suspect, that particular FCC. And so it went up into the D.C. Court of Appeals, which was the natural place for it to go, and our side was upheld. The other side appealed it to the Supreme Court. The Supreme Court refused to take it. So in effect, what has happened is that the fairness doctrine is suspended, but a new FCC could put it into effect if it wanted to. Could reestablish it, but no one has done that. There's only been a little talk about that among some liberals because they object to conservative talk radio and they want the fairness doctrine to apply to people like Rush Limbaugh.
What exactly is the fairness doctrine, by the way?
The fairness doctrine says that you have to cover significant issues in your community and that you have to present contrasting views on those issues. That's what serving the public interest means, according to the fairness doctrine. But it's been suspended, so broadcasters are not required to do that anymore.
In fact, in preparing to apply for a license or preparing to apply for a renewal of a license, for many, many years, decades, broadcasters were required to go out into the community and do what were called ascertainment interviews.
That's right.
To discover what the community issues were, what the sides were, who the spokespeople were for the various sides. Was that in order to buttress the fairness doctrine?
Absolutely, because you had to give contrasting views to responsible members of the community. What got Eugene Wilkin in trouble, he did the right thing. The 8 people, the 8 neighbors, were a splinter group of an environmental group. They weren't really representing the community. They were not what you would call the responsible majority interest.
In fact, the environmental group actually agreed with Mr. Wilkins.
That's right, that's right. And he was eventually exonerated, but it ruined his career because all the legal bills that were charged against that poor little station in Spokane.
So the owner of the station of which Mr. Wilkins was the general manager said, Mr. Wilkins, you've cost me too much money.
Yep.
You're out of here. Your career is over.
Yeah. Yeah.
So the chilling effect was in fact even greater than that which might have otherwise been available under the fairness doctrine.
Absolutely, absolutely.
What about the notion, and I know that you were, I believe you chaired the communications department at California State University, Long Beach for some time. What about the notion that fairness and equal time are just good broadcasting? They're just good business. You ought to do it anyway.
Well, because you don't know what it is. The use of the term fairness, and as you pointed out earlier, the use of the term public interest is so arbitrary that almost anything can be made of it. And when that happens, you can get in trouble. Equal time provisions are an intrusion on a broadcaster's rights to control their own station. Newspapers don't have to take advertising if they don't want it. Newspapers don't have to put an ad by you or against you in their newspaper if they don't. And radio stations and television stations should have the same freedom under the First Amendment, in my opinion.
Is the difference here the notion that anybody can have a printing press and can print up to their heart's delight whatever they want? They can become the Benjamin Franklin of their neighborhood, and they could pamphleteer everything, but the broadcast spectrum is limited, and therefore these resources are relatively scarce.
That was the original rationale, and that was what was bought in the 1969 Red Lion case. But it's no longer true. Obviously, we have many more radio stations and television stations than we have newspapers. And if you start your own newspaper, you have no guarantee that anyone's going to read it. Most newspapers now are the only game in town, so they're far more powerful than a broadcast outlet, which is divided up into the cable spectrum added on into hundreds of stations in every community. And so it makes no sense to restrict them and not restrict the newspapers.
And then there was the fascinating and perhaps even game-changing observation by a certain federal judge who said, well, now, excuse me, never mind this whole thing about what is fair, what is not fair, what is equal time, and all of that. What's the notion of scarcity of broadcast media got to do with it in the first place? How does scarcity even enable these other arguments to take place? And of course, that judge was Robert Bork.
That's right. Bork was ruling on a case when we started teletext, and they wanted to apply the fairness doctrine to teletext. And he struck that down, rightfully so. But in the process, he wrote a wonderful decision. He said, you know, if there's a scarcity of ink, could we then restrict newspapers? And of course, we've broadened the spectrum, and there are places in the country where you can't give away broadcast spectrum now.
So because of Judge Bork's decision, basically he ruled that the whole rationale for the fairness doctrine was suddenly absurd.
Yes, absolutely. Absolutely.
And that leaves us where now in terms of any issues of fairness or equal time or editorial reply or whatever?
Well, the equal time and equal access rules are separate. They were promulgated in 1934 under the first Communication Act that applied to television. All of the stuff that flows from the fairness doctrine has since been done in. The corollaries, the Zapple rules, and the personal attack rule. That's all been done in. But it is suspended. The bottom line in the ruling by Bork is that the FCC has the authority to suspend it. That's what the case was about. So the FCC had not applied it to teletext, and then they suspended it to everybody else, and that's what Bork upheld. But we've never had a ruling as to whether it was constitutional in the first place. And
in fact, in your book, The Four Freedoms of the First Amendment, on page 99, you've been talking about licensed radio and television stations. You say eventually the FCC was also given governance over cable and satellite television. Really? I missed that. How did that come about?
Yeah, they make the rules because the Federal Communication Commission was in charge of all telecommunication. They're in charge of telephones, they're in charge of satellite broadcasting and cable broadcasting. And so they can say things like, well, on cable, because you invite it into your home, you can watch obscene material. But on direct broadcast, you can't because your kid can tune into that.
Well, then that brings up the whole issue of what is obscene or indecent or lewd? Can you broadcast it over the public airwaves? Can you allow it to be distributed into homes via cable or via satellite, as you point out? And can you be restricted in terms of what time of day and who might be the audience watching at the time? What's all that about and where do we stand?
Well, it's very complicated. You know, the rule is that something is obscene if it has no redeeming social value, when the work is taken as a whole. It's obscene. It also has to appeal to prurient interests, that is sexual interests. It has to be graphic. And so to meet all of those standards, it's very difficult for something to be obscene. To be indecent, it meets a lesser standard. The context can imply obscenity, and that makes something indecent. And that gets us into all kinds of trouble with the FCC, because sometimes they say, well, you can't say a dirty word. Here's the specific word you can't say. And in other cases, they say, well, in context, you implied that word. Well, no, I didn't. How do you know that? And you can get in trouble with your license over indecent material. The landmark court ruling in this was the Pacifica case in 1974, I think, in which George Carlin's monologue about the 7 dirty words was played in the afternoon on a New York radio station.
The famous underground station WBAI.
There you go, there you go. And they appealed they were reprimanded. Their license wasn't taken away, they were just reprimanded. And they appealed all the way up to the Supreme Court, and the Supreme Court upheld the FCC's right to censor them, arguing that radio is a uniquely pervasive medium that can get into all of our households, that kids can tune into, and that this was the wrong time of day for it to be on. And so the FCC has since ruled that, you know, up until a certain time at night, you can't use dirty words, you can't have indecent material. But after that time, from 10 to 6 in the morning, 10 at night to 6 in the morning, you can have that material. I mean, it's really bizarre that these rules are in place and that this kind of censorship can take place.
And of course, the George Carlin 7 dirty words you can't say on television That was pre-recorded, and it was premeditated that they were going to put that on the air on the station in Long Island, New York. What about the issue of things, for example, happened, and I think it was the 2004 Super Bowl halftime performance, or backstage at it was the Grammy Awards or whatever, where one of the winners came back and said, "Yeah, I'm blank and blank excited about this."
Right.
What about these live things that were not intentionally broadcast? They just happened.
Exactly. I mean, the broadcaster is not responsible for that. When somebody violates the script or does something that was unexpected, Adam Lambert recently on one of the broadcast shows kissed another man, and that wasn't in the routine, and ABC cut it for the West Coast. I mean, this is the kind of censorship that we're living under because of these rules that are promulgated by the FCC. I think that the courts need to go back and ask themselves, what is the harm in this material? What's the damage being done here? What's the compelling government interest in censoring this kind of material?
And as I understand it, I didn't see the program, but on Barbara Walters' 10 Most Fascinating People of 2009, she did not show, and pointedly said she was not showing the Adam Lambert male gay kiss, but did show a similar situation among two women involving Lady Gaga, another one of her most fascinating people. I'm confused. As a consumer, I don't get it.
Yeah, I think there's a double standard here. And these rules allow for that kind of double standard, and that's what makes them dangerous. That's why they have a chilling effect. You can be darn well sure that after the 2004 Super Bowl, there was a 5-second delay on everything so that they could blip anything that appeared to be indecent.
And in fact, I work for one of the larger companies, and I'm required to go through special training and take tests every year to make sure that I understand those things, even though the company, frankly, is protecting itself. They're not protecting me, so that they can say if something goes wrong, well, we gave him training and he just violated it.
That's right. That's right.
And speaking of consolidation, as we wind down this half hour, things like Comcast taking over NBC Universal, there seems to be, instead of a proliferation of the regular broadcast media, the broadcast media seem to be contracting, and it is these new technologies that are now proliferating.
That's true. And, you know, it's interesting that all of these controls have been put on broadcasting, and they weren't put on the internet. The internet was, you know, run by cowboys and was out there, and it was freedom and libertarianism. And again, it seems to me very unfair to put the broadcasters in one category and everybody else gets to do whatever they want.
And finally, all of this comes back to the First Amendment. In what way does all of this, if you can kind of pull this half hour back together, in what way does the First Amendment oversee the whole overarching area that we've been discussing?
Well, just remember what very clearly in plain print, the First Amendment says, Congress shall make no law restricting freedom of speech. And here we are with Congress implementing FCC rules that certainly do curtail our free speech.
A fascinating half hour with the man who wrote the Four Freedoms of the First Amendment, Dr. Craig R. Smith, the director of the Center for First Amendment Studies and professor at Cal State University, Long Beach. I'm Jack Popejoy. Thank you for joining us.